Welcome to The Print. The Supreme Court has pronounced its judgment on Article 370, and it has essentially upheld the abrogation of Article 370 back in August 2019. What have the 5 judges said in this humongous almost 480 page judgment? We are here to tell you. I am Apoorva Mandhani. With me, I have Bhadra, Sinha, our editor here of all things law, and we have with us Supreme Court lawyer Archana, Pathak. Thank you so much for joining us, Archana.
Thank you so much, Archana. So finally, the judgment gets delivered almost 4 years after a batch of petitions challenged the centre's move to do away with Article 370, which gave a special status to the erstwhile state of Jammu and Kashmir. Now, of course, there are 2 union territories over there. Archana, you were representing, I think, one of the interveners in the matter on behalf of a women's group. You had argued and taken this line of argument that imposition of Article 370 and Article 35A actually took away the rights of married women from J&K, because if they get married to a community outside J&K, they lost their right to own land over there. So I'm sure you are really delighted with the judgment because it has gone in favor of your client. Before we go and talk about what the judgment actually says, could you just very briefly talk about what the petitioners had argued and how the centre defended the abrogation?
Yeah, so Bhadra, this was reserved on 5th of September 23, and after 16 days of marathon hearings, if I can say that. And yes, I appeared for one of the interveners. They were the displaced people from Kashmir. I had many points to argue, but over a period of so many days, all the major points were argued. So I had basically focused my arguments on these issues which you have just now said. So if we can just sum up the entire judgment, the petitioners...
Just talk about the petitioners' argument and centre's rebuttal first.
Yeah, okay. So the petitioners had mainly said that Article 370 was a permanent feature in the constitution. So they had said that it was not a temporary feature and it had to stay on for eternity. That was number 1. Number 2, they said that the president could not have issued the proclamation in view of the fact that the state legislative assembly was not there, or the constituent assembly that was used back then, that was not there. So in the absence of any consultation with the state legislative assembly, 370 could not have been abrogated by way of a president's proclamation, on which the centre said that mainly the force of the argument was that 370 was always a temporary provision, it had to go. So, and even the instrument of accession back then always laid stress on the point that it was a temporary provision, and once the normalcy could get back in the country and in the state back then, it should have been removed long back. In fact, it has taken really long. And imagine there were always 2 constitutions in our country, 2 flags, and this is not there with any state which was finally taken into Union of India at the time of independence. So this special status was there only temporarily, and it had to go one day. This is already very late. It was the main argument of the centre. And also the fact that the president has a primacy and the president could have issued proclamation even when there was no state assembly. So these were the main arguments of both the sides, and in fact the state or the union also gave data which reflected that the situation in the valley now is very peaceful. It is normal now. The terrorist operations have also come down. There are youth which are now back trying to do their work, trying to establish their business. So all these were very positive aspects which happened only after 370, because you would know that because of 370 there were so many things which were denied to the state of Jammu and Kashmir, like you did not have the fundamental rights which were available to the entire country. Next, you did not even have right to education. Now these are very, very important points which important rights which the state of Jammu and Kashmir did not have.
Archana, there was also another point of challenge, which was the bifurcation of the erstwhile state into 2 UTs, and I think that was done through the Act. So, if you could just briefly point out the arguments with regard to this issue, and then we can, move forward to talk about what the judgment has said.
Yeah, so the entire state of Jammu and Kashmir was divided into two union territories, Ladakh and Jammu and Kashmir. So it was also challenged that it could not have done this kind of a bifurcation, but on which the Solicitor General had said, and if I can just read that conclusion point in the judgment, it said the Solicitor General stated that the statehood of Jammu and Kashmir will be restored except for the carving out of union territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the union territory of Ladakh in view of Article 3A, read with explanation 1, which permits forming a union territory by separation of territory from any state. However, the court has also directed that the Election Commission of India to actually hold elections and by 30th of September 2024, and restoration of statehood shall take place at the earliest and as soon as possible. Okay. So the court has finally directed that the elections should be held as soon as possible, so that even this issue can be resolved.
So you have spoken about two important directions that have been given in the judgment today. First is with regard to the restoration of the statehood, and second is with regard to holding elections in J&K.
Correct.
And with regard to the carving out of union territory of Ladakh, the Supreme Court has said that it is valid. But Archana, what about with regard to the Statehood Act that actually divided the state into two UTs? What has the court said on that point?
No, the court has not said anything because of the assurance given by the SG that we will be having elections very soon there, and this issue will be resolved. Okay. So the court has not really deliberated much upon this.
So as far as the challenge to the Statehood Act is concerned, the reorganization of J&K Statehood Act, I think, if I'm not mistaken, as far as the challenge to that act is concerned, the court has said that it's not going to go into that question as of now, and it has kept it open.
Correct. I'll also tell you, Bhadra, there was one more important point that the petitioners were harping upon, which was that the Jammu and Kashmir had the internal sovereignty. The court has finally come to a conclusion that the moment that instrument of accession was signed and Jammu and Kashmir became a part of India, there was no sovereignty which was there with the state of Jammu and Kashmir. And if by a president's proclamation, the state of Jammu and Kashmir has come now within the fold of union, and after the abrogation of 370, it is because of the fact that there was no sovereignty at all of the state of Jammu and Kashmir. So this was one important observation given by the Supreme Court. I'm reading from the judgment.
Okay, but what was the exact argument around sovereignty? The petitioners had said that since it's a sovereign, it has an internal sovereignty, so the president could not have issued the notification or the proclamation without the concurrence of the Constituent Assembly or the State Legislative Assembly, right? Correct. So this was the argument.
Yes.
Now, with regard to this argument, what is the final decision of the Constitution bench today?
So I'll just read out in the beginning only what the Supreme Court has finally said
with regard to the
element of sovereignty,
as well as the proclamation by the president.
Okay,
right?
Yeah. So the court says the state of Jammu and Kashmir does not retain any element of sovereignty after the execution of instrument of accession and the issuance of proclamation dated 25th November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. So this is what finally the court has come down to. Once in 1949 you were made a part of the Union of India, even though the entire constitution was not applicable on the state of Jammu and Kashmir, but still once you agreed to become a part of the Union of India, so you lost your internal sovereignty back then.
Okay, and what about the president's power to abrogate Article 370? Or should we first talk about whether...
The nature of Article 370 probably.
No, before we touch about the malafide part, let's talk about the nature of Article 370.
So maybe before that we can speak about... So maybe before that we can talk a bit about what the court said on the nature of Article 370, because the petitioners seem to argue that even though it was called a temporary provision, it had acquired a permanent status in our constitution. What did the Supreme Court say on this?
Yeah, so this Supreme Court actually went into the historical aspect also while discussing in the judgment, and the court finally said it can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. So, all along the court said that it was never meant to be a permanent provision. It was always, right since from the beginning, it was always a temporary provision, and that is why the President's proclamation is valid and could have been done even without there being any concurrence or consultation from the State Legislative Assembly.
So, another question is, Archana, that how has the court dealt with the petitioner's argument that in the absence of a constituent assembly, the President could not have abrogated Article 370.
Just for some context for our viewers, just to set a base here, Article 370 subclause 3 said that 370 could cease to operate on such a declaration by the President, but a proviso, which is it said later that provided that the constituent, there needs to be a recommendation from the Constituent Assembly on such a proclamation by the President. So this was the contention there, that whether Article 370 could cease to operate without such a recommendation from the Constituent Assembly. So if you could just explain that.
Yeah, so the even while the arguments were going on in the court, the petitioners were really harping upon the fact that without any concurrence, and this was their basis right from the beginning, that without the concurrence of the State Legislative Assembly, the President could not have issued this proclamation, and the constitutional order of 272 and 273 are ultra vires. But the court has finally come to the conclusion that the President in the exercise of power under Article 370 subclause 3 can unilaterally issue a notification that Article 370 ceases to exist. And the only one thing that has to be seen is that such an exercise or such an action should not be mala fide. And we can see that once after the abrogation, the entire constitution has been applied on the state of Jammu and Kashmir, means that it was not a piecemeal effort. This clearly establishes the fact that it was not a malified exercise, and it was done in good faith, and since the entire provisions of the Constitution of India is now there for the state of Jammu and Kashmir, so therefore the exercise is not malified, and therefore the abrogation of Article 370 is perfectly valid. If you want, I can just also read.
No, just to point out here, with regard to the President's power, what has the court said, in the sense, as Apoorva pointed out, that the proviso to Article 370 said that provided the Constituent Assembly's recommendation is there. How has the court dealt with that argument of the petitioner? So was it necessary for the President to get a recommendation from the Constituent Assembly or not? Because the petitioners had very focusedly argued that since there is no Constituent Assembly in J&K, that is why Article 370 is a permanent feature of the Constitution. How has the court dealt with this argument of the petitioner? What is it saying particularly about Proviso 3 of Article 370?
Yeah. So the court says in the conclusion in para H, if I can just read those 4 lines, it says the President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second proviso to Article 370 subclause 1 subclause D, while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Article 373, for which the concurrence or collaboration with the state government was not required. So that is how this the finally in the conclusion the Honorable Court has said that it was not required, because the President already had the power under 373. So the concurrence was really not required.
So basically dissolution happened of the Constituent Assembly.
Correct.
Right? After the independence. But as far as the President's power is concerned under Article 370, what the court I think has said is that power continues to be there. That power is retained. Right?
Correct.
So the dissolution of President's power hasn't taken place, but only the Constituent Assembly has been dissolved.
Yes, because it also says further, the President had the power to issue a notification declaring that Article 373 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370 subclause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370 subclause 3 is a culmination of the process of integration, and as such is a valid exercise of power. Thus, the constitutional order of 273 is valid.
So just for some context for our viewers, Article 370 subclause 1, subclause D, I know it's a mouthful, but what it says is that certain provisions of the Constitution of India could be applied to the erstwhile state of Jammu and Kashmir if the President issues such a declaration. Of course, this it said, the proviso that she just referred to, it said that this can be done with the state government's concurrence. So this is what was referred to by the court, saying that since over the years several provisions of the Constitution have been applied to the erstwhile state of Jammu and Kashmir, that means there was a gradual process that had been happening over the years of integration of the erstwhile state with the Union of India. That's what the court meant to say.
So I'll just tell you, Bhadra, here that after this judgment, imagine the impact now. So we have now one national flag for the entire country.
That's what I was about to ask. Exactly. So that is exactly what I was going to ask you. That now you had mentioned about two constitutions, right?
Correct.
So what is the impact of today's judgment? What happens to the constitution of J&K now?
So now after the judgment, the constitution, obviously the constitution of Jammu and Kashmir had gone after the abrogation of 370, but of course the matter was pending, it was sub judice. Now finally the judgment has come, and now finally after so many years of independence, now we have one national flag for the entire country, we have one constitution. All the fundamental rights are now available to the people of Jammu and Kashmir. They were longing for it. We have heard about the people who were the Safai Karamcharis there. In spite of them being for generations now, they were not given so many rights which the original people from Jammu and Kashmir had. Then the status of women. So the man, if they married outside Jammu and Kashmir, they could have all the rights to acquire and to hold land, the ancestral land, etc. But if the women married outside, then they were not having that right to have that land. So that is these are, I think, very, very important things which are now there for the entire country, including, because see, in all the acts, the central legislations, there was always this section that the act applies except to the people except the state of Jammu and Kashmir. So all that is now gone. The entire country is one. In fact, if I can just tell you the figure, 890 central provisions are now applicable in the state of Jammu and Kashmir. So something, if I can just say it here, there was a wrong which was committed earlier. There were so many other states which were there and the entire which were there taken inside the Union of India back then, but it was only Jammu and Kashmir which was given this status. It should have gone earlier, but sooner the later. So I think it's a very, very welcome judgment, and I'm very happy about the fact that the entire country is one now.
With this, we've reached the end of this video. In this video, we told you about what the Supreme Court has ruled in its judgment upholding the abrogation of Article 370. In addition to this video, we've made several other videos, and Bhadra here and I have written articles on the opinions that the 5 judges have given out. Of course, 480 pages is a lot to read, but we have crunched it into smaller pieces. So if you do want to read those articles or see those videos, we've added the links to all of those articles and videos in the description of this video. Thank you so much for watching.
Thank you.